with the entry, he would have been faced with a far different strategic decision. That would be that he would have two prior statements of the witness, contemporaneous and prompt statements, and he would be left with arguing the unreliability of the hospital entry versus the prosecutor's attempts to undermine the reliability of the apartment entry, which is a far different, and I would say less clear and weaker strategy that you only have one prompt and contemporaneously recorded statement and then the witness's trial testimony and the other material that he did have. So I think that perhaps while he would have focused on the inconsistencies, nonetheless would have been a far different strategy, and he certainly would not have built the defense case that he did by carefully developing this strategy leading up to re-cross-examination of the final prosecution witness, where defense, in reliance upon the prosecutor's full disclosure and upon the police officer's prior answer that he had not made any additional entries, he sought to establish the distinction between a prior consistent statement and a prior consistent statement as recorded in an entry. Only at that point was this entry revealed to defense counsel, and at that point his strategy was slammed shut. Again, even the prosecutor's own explanation to the court reveals that he recognized the vastly different value of these two entries. When he had only the ECAB report and the grand jury testimony, he expressed concern to the police officer about the inconsistencies between his entry and the witness's grand jury testimony. Yet after he knew of this entry, he allegedly expressed confidence to defense counsel that he had something that could clear that up, that he had an explanation. So clearly to the prosecutor, these items were not duplicative equivalents. So, Your Honors, where in this case, in Perez, this court stated the purpose of the Rosario rule was to advise counsel not only of what questions to ask, but also of what questions not to ask. Here we have an entire strategy, an entire defense case that the defense would not have embarked upon had they been given this entry. Once more, just to address the people's point that this was a duplicative equivalent of the ECAB report, the memo book entry was a statement allegedly recorded contemporaneously during the hospital interview a mere 7 hours after the incident. On the other hand, the ECAB report was an assistant district attorney's account of the police officer's account of the witness's statement. Again, while it was undated, the officer testified that he had that interview 7 hours after the hospital interview. Finally, Your Honors, as to the respondent's point that defense counsel was given disclosure of this document when the prosecutor represented to him that he had an explanation, I would remind the court that, again, you have held time and again that physical delivery is what is required to satisfy Rosario, not simply oral notice. And here, without conceding that any type of oral notice would satisfy the rule or even diminish the surprise to defense counsel where the prosecutor has not supplied Rosario material, the conversation represented here is far from one where the prosecutor said, I have an entry, it's consistent, yet simply failed to turn it over. It was far from that. If the court has no further questions, I will conclude. With full knowledge of the theory of the defense, the prosecutor had in his possession Rosario material which would prove fatal to the defendant's strategy. The ultimate disclosure of this entry, only after the defense strategy had effectively been nullified, cannot now be asserted to excuse this Rosario violation. Thank you, Your Honors.
Thank you very much.
May it please the court?
Yes, Machine.
Judge, what was fatal to the defense strategy in this case was not the late disclosure of Rosario material, but rather that the jury simply did not believe the defendant's self-serving and bizarre tale of what happened on the evening of this rather heinous offense. The people concede, yes, there is clearly a Rosario violation here, but this is not a case where there is a complete failure to disclose Rosario, and therefore it does not come under the per se reversible error rule set forth by this court in Rangel, but rather it comes under a delay in disclosure, and therefore this court must examine whether the defense was substantially prejudiced by reason of the delay.
Isn't it a classic sandbag?
No, Your Honor.
Lying back, knowing that you've got something that contradicts the statement upon which you think or perhaps hope defense counsel will cross-examine on and put all his eggs on, and then you, after he does so, then you come back with redirect and destroy the effect of his cross-examination.
No, Judge, and
That's not what happened.
No, that's not what happened here, and that's why this is clearly, I believe, distinguishable from Perez. Because in Perez, the prosecutor did know that it was clearly going to be the basis, the witness's credibility would be the basis of cross-examination. He clearly had the transcript in his hand, and he clearly used that transcript without notifying the defense of the contents. Here, although not physically transmitted to the defense attorney, the prosecutor, as an officer of the court, affirmatively stated to the court that he had informed the defense counsel that there was an explanation for the inconsistency, that it was in the memo book, and therefore the defense counsel was on notice. In fact, the defense counsel knew of the hospital interview between Officer Horter and the complaining witness, and in fact conceded that he knew of it as early as the hearing. He did not, however, know the fact that it had been recorded in some fashion in the police officer's memo book. Therefore, the fact that it was not physically turned over is, yes, a Rosario violation, but the fact that he knew of that there was an explanation for the consistencies or inconsistencies goes to whether he was substantially prejudiced by reason of that late disclosure. And here, although the defense counsel argues that his whole trial strategy was eviscerated, the strategy at trial was that the defendant went to the victim's apartment where the victim, who was a prostitute, took his money. And the whole central issue at trial was that the defendant had to take the stand to give his testimony to get his point across. The strategy of going after the complaining witness was to attack her credibility, but it was not the focal point of the defense strategy. That focal point was the defendant's testimony itself. And here, he would have testified regardless of whether he had received this memo book entry prior to trial or whether he had received it in the middle of trial. That was not his entire defense strategy.
But you're speculating when you say that. You really don't know what his trial strategy would have been had he had that.
That's, in a sense, that's true, Judge. I am speculating, and this court has held that.
You made the statement, excuse me, I'm sorry.
Oh, that's right. Just let me quickly finish. That you should not speculate as to what the defense strategy would be, but however, I think the record as a whole should be examined to see whether there is a potential strategy that would have differed, and whether that strategy is substantial prejudice under Perez or the Rosario decisions.
You made the statement just now and in your brief that defense counsel knew about this other statement from the outset, was aware at all times that there was
Knew about this statement or the recording in the memo book?
the recording in the memo book. Can you fix a place in the record where we can establish that as a fact?
Well, I don't believe in my brief it states that he knew about the recording in the memo book from the outset. However, let me see if I can find, I believe it was during the colloquy when the prosecutor stated to the court that he informed the defense counsel that morning when he had made Mr. Smith available for him to interview prior to his testimony at trial, that he informed him of the inconsistencies and that Officer Horter had memo book entries that would clear that up. And let me just look for where that is.
There doesn't seem to be any record citation in your brief, that's why.
That's what I'm just, colloquy pages 213 to 214. Where he informed the court and that he had told the defense counsel of it, but that and there was no explanation as to why he didn't provide him immediately with a copy, and I'm unable to speculate as to why that did happen. Regrettably, it did not happen. Otherwise, this issue would not be before the court.
And one of the reasons for the rule being ironclad is that the court should not substitute its judgment with respect to whether or not the defense counsel would or should use a particular statement. It's up to the counsel to make that determination with the single-minded devotion which counsel has to the cause.
Perhaps that's true, Judge, where there is no disclosure at all, so that there's no opportunity for a defense counsel to seek redress in the court in which he is in front of. Here, the only remedy sought by the defense counsel was either a mistrial or dismissal of the indictment, which clearly would have been drastic and inappropriate given what the court determined to find to be insignificant prejudice, if at all, from the fact that the memo book entry had not been disclosed earlier. Given that he did have the opportunity to seek either preclusion of testimony concerning that, he could have, in fact, basically used damage control and not proceeded to question the officer any further about it, or he could have sought a curative instruction in the form of perhaps a strongly worded charge to the jury that the prosecutor had not upheld certain legal
Except that
obligations.
his whole strategy of defense might have been altered right from the outset. And having been, to use Judge Hancock's expression, sandbagged, he felt that his cause was beyond redemption, and the best thing for him to do was to throw in the towel.
Judge, it's clear, I believe, in this case that from the outset the defense would be that the defendant would be testifying, that that was the only way to get in front of the jury what the defense was, that he was not legitimate, that he was not in the victim's apartment for an illegitimate and illegal reason, but that he was there simply to regain his money from a prostitute. There's no other way that defense could have come forward.
He might well have testified, irrespective of knowledge of the entry.
Mhm.
But is it not possible that his cross-examination would have been different in emphasis and in the way it was handled? Is it not also possible that, perhaps this is even more important, that his opening might have been different?
Judge, the opening in this case stressed to the jury that the defense counsel wanted the jury to retain an open mind concerning what it would hear, that the victim had come up with two different stories about what had happened. In fact, he capitalized on what occurred here and argued to the jury in summation that the victim had come up with more than 2 stories, had come up with 3, and mentioned the fact that, excuse me?
But the third one was not beneficial to defendant's cause. The second one and the first one, the contradiction was. Third one took all the wind out of his, not all, but some of the wind out of his sails, allegedly.
But he's not arguing that it was the testimony concerning the hospital interview that was so detrimental to his case, but the fact that he didn't know there was a memo book entry. He's the one who chose to disclose the entirety of that memo book entry to the jury. He could have just left it simply, did you make any notes of this? The officer could have said yes, and he could have left it at that and retreated. The prosecutor never introduced that entry. He never brought it up. He brought up testimony concerning the entry when defense counsel had opened the door on that. In fact, had been mentioning it throughout the course of the trial that there are all
Thank you
these
very much, Ms.
stories.
Sheehan.
Thank you, Judge.
People versus Jimmy Martinez. Mr. Kasperi, what are you looking for here, a new trial or a hearing?
Well, we want at least a hearing. We'd also like a new trial, Your Honor. Let me explain that initially, I thought that the prosecutor had conceded the hearing question, and I wasn't going to address that. However, I was informed about an hour before the argument when the prosecutor gave me another copy of her new conclusion that she will be raising that issue, so I'd like to just go through it briefly. I think as the court had recognized in Jones, the prosecutor has to turn over the Rosario material that's in his possession, because otherwise defense counsel ordinarily either has no knowledge of it or has no means of obtaining it. That means it's especially important for defense, or rather for the prosecution, to perform a diligent search. They have to do more than just check the files. They have to speak with the witnesses. They have to request the sprint report, which in this case wasn't requested until just the eve of the eve of the trial. And because the prosecutor didn't do all that, we say in this case that there was a need for a hearing. There's nothing more that defense counsel could have done that he didn't do. Moreover, we're also arguing for a new trial because we believe that in this instance, and only in this instance, that a hearing wouldn't do justice. The problem that we have is at this juncture, there's already been a 4-year lapse since the time that the officer first got the information from Gonzalez. And we believe that no matter what the results are, there will be prejudice to our client if the hearing is granted. Let me just go through the results. First of all, there are 2 possible results. Either the missing material will turn up, it will be produced, or the missing material won't be. Let me turn first to the possibility that it is produced. And I want to note that if it is produced, the court should reverse, notwithstanding a slight possibility that the material would prove duplicative. I want to note first that there's only a slight possibility of that missing material being duplicative. I mean, if the descriptions that are in the Sprint report, the descriptions that are in the missing material differ, I understand from your ruling in Rangel that you would not hold that to be the duplicative equivalent of one another. Generally, descriptions in Sprint reports are pretty cryptic. The idea is you send out a Sprint report or you send out a radio bulletin as soon as you get an initial description. And indeed, that's what Officer Raycraft testified to at the hearing. She said that initially, Officer Mosley jotted things down only for a few seconds so he could get it out over the air quickly. And then later there was a fleshing out of that description.
Well, the only description that you had here really was from the manager. Wasn't that correct?
The only description...
You didn't have anything from the victim, did you?
Well, we have a description that's on the Sprint tape. Ostensibly, that Sprint tape...
But the ID was not made by the victim after the incident, was it? It was made by the manager.
Well, the ID is made by the manager, that's right. He goes chasing after the suspect, and he believes... Actually, it's an important point because he really hasn't seen that man much. He's only seen him in the restaurant for a few minutes. He didn't realize his significance at the moment. And then he's alerted to the crime, and he goes chasing out down the street, and he sees someone he thinks resembles that person. He
Well, the
goes
same
down
fellow
there.
he saw in the restaurant happens to be coincidentally the one running away from the restaurant.
Well, I don't think that he saw him running away from the restaurant, you understand. He saw him going down subway steps. In the Times Square area, a lot of people run. And you really can't say conclusively that this is the man.
At any rate, the critical identification would have been from the victim.
The critical identification is from the victim, and the only thing that we have to that extent is a Sprint tape that went out that reflects a radio run, and that's usually done immediately after the description is first given. There's then a fleshing out of that description, and it's that fleshing out that we believe is the material that if we don't have, would prejudice our client.
Do you know for a fact whether that material exists or not, or is it just a request that if it exists, you want it?
Well, the idea is that the reason we don't know whether it exists or not is precisely because the prosecution has failed in its burden to produce and locate. If the prosecution hadn't done that, we would have information in this case as to what happened.
So that to an extent, this would be an extension of Rangel and Jones in those cases, because now we're moving the per se rule to the mere invocation, whether material exists or not.
Well, I don't
If you
think-
go to your ultimate request for relief, which is a new trial.
Well, I don't think that it's actually an extension. I think this is a result that's necessary to effectuate Rosario as this court has already adopted it. The idea is that if we don't have an incentive for the prosecution to turn over the material, to locate it and to produce it, then there's nothing the defense counsel can do to find that material.
But
If
that
they have
all
to have-
presupposes the existence of the material.
Well, it does presuppose
Also
that.
presupposes the materials being Rosario material.
Well, it presupposes all that,
How do
that's
you
right.
reach this? Do you have
Well-
to have a hearing or something, or what?
Well, I think the problem with the hearing, I think ordinarily that would be what we request. If you have a situation at trial for which, for some reason, the prosecution has overlooked material, there should be a hearing to determine whether that exists. However, at this juncture, we're so far past the time that we believe it would prejudice our client to grant a new hearing in this case. And we're saying you're going to have to presume something, in essence, because we can't...
Let's just
Yeah,
take
I'm-
that statement.
All right.
Assume that there were a hearing,
Right.
and at the hearing developed that indeed there was no material, let alone no Rosario material.
Well, I mean, the only...
Then if we applied the per se rule as you would have us, there would really have been no reason for dismissing the indictment. There never was any Rosario material.
Well, you understand, Your Honor, that the problem with this is that in order to determine whether that Rosario material still exists or not, or the more relevant question, whether it existed at the time of trial, we have to bring in a police officer whose recollection is now 4 years old. And the reason his recollection is now 4 years old is the prosecution never approached him before. I mean, not even after trial did they approach him to determine the facts. Indeed, I think it's very interesting that on the eve of our hearing here today, the prosecutor went to Officer Mosley and got a copy of his memo book entries, and then presented them to me 1 hour in advance. I mean, the whole idea is that if we don't have that material, we don't have a questioning or hearing in time, we won't know what that hearing would have shown up.
Bill, when was the first time the possibility of the existence of this memo book entry became known?
Well, it was on the eve of trial. Gonzalez was testifying at the hearing, and he let slip that there was that he had been interviewed by regular police officers. The arrest in this case was by a New York City Transit police officer, but he said that he had been interviewed by regular police officers, and he stated that one of them had written down a description. That was the first time that defense counsel could have known about it. The problem is that if the prosecution had subpoenaed those Sprint reports, had gone ahead and subpoenaed 911 statements, and I think there's a real doubt as to whether the prosecutor went ahead and did that, or had given an in-depth interview of Gonzalez, this information could have been turned up well before that time. Even assuming that it couldn't have been, I mean, at that juncture, it has to be the prosecutor's burden to go and find that material.
Mr.
Someone has to-
Kaspari, as I hear you, though, I gather what you're now saying is that the passage of time is what requires the extra sanction of the new trial rather than the natural consequence or analytical follow-through of the nature of this error, if it is error. Is that what you're really saying?
Well, what I am saying is that the problem we have in this case, why a hearing wouldn't be sufficient, is due to the passage of time, to the failure of the prosecution to locate that material and turn it over.
So apart from your facts, in this case, on behalf of your client, and the passage of time, what would be the rule of law you would have us espouse if you were to prevail with respect to this kind of error?
I think you should limit it narrowly to the facts of this particular case. I think the rule that you have to espouse in this instance is that if the prosecution has that burden to locate and produce, they have to go ahead and perform that burden. And if that means that after trial, if they have to ask for an adjournment, which in this case they never did, if they have to, during the trial, ask for a hearing as soon as Officer Mosley turns up again, if immediately after the trial they have to ask for a hearing and get a hearing so that we can determine what actually happened to that material, that should be the prosecutor's burden.
Narrowly applied to this case means you get a new trial, everybody else gets a new hearing, depending upon what the time period is?
I think that the new hearing would ordinarily, in the ordinary course of events, be sufficient, because if you look at it prospectively, you have a different instance than if you're looking at it from retrospect.
You say a hearing to develop what happened to the material, but again, it presupposes that there was material. Does there have to be some showing before you get to this hearing of the existence of the material?
Yeah, I think that's a point that's gone into by Poole. I mean, we really are asking for a Poole hearing in the ordinary course. The idea that if you have a good faith basis for arguing that that material exists, in this case we have Officer Raycraft's testimony, that should be the basis for going ahead and granting.
Thank you, Mr. Kaspari.
Thanks, Mark.
Staley?
Your Honors, I would like to begin by addressing one of the opening comments made by Mr. Kaspari, which refers to my conclusion page. I did, in fact, prepare a different one, which I gave to him right before the argument, And I told him simply that I was going to request the court's permission to file an amended conclusion, simply because I felt that the one that was filed does not reflect the thrust of our argument throughout the brief. And as the court, I'm sure, has noticed, the thrust of that argument basically is that there's no basis on this record for concluding that the people failed to turn over any non-duplicative Rosario material to defendant.
Mr. Gaspar is complaining that the last page of your brief now has become Rosario material.
Well, I apologize for turning it over to him just an hour before the argument, but I think it is important, Your Honors, to note that there is no basis in this record for finding that we didn't turn it over. And I think perhaps it would be helpful if I went through some of the chronology of exactly what happened at the hearing and the trial. On November 22nd, Mr. Gonzalez testified that, in fact, he had spoken to several police officers at the scene, and that he had given them a description. He said that one of them made out a report. On November 23rd, the prosecutor represented to the court that, in fact, he had subpoenaed the 911 tape and had never received a copy of it. He did not get that tape until the 28th of November in the afternoon after he returned from the luncheon recess. He explained to the court that it contained a rather detailed description. He read that into the record. He saw that there were other officers who responded to the scene, and he indicated that he was making every attempt to get them to court. On November 29th, the jury was selected. On November 30th, the judge gave his preliminary remarks to the jury, and on December 1st, Officer Raycraft came in and testified as to exactly what her participation in the response to the robbery was. By the way, the prosecutor found out on November 28th that Officer Mosley was on vacation until December 7th. He was upstate on a hunting trip, and that is why he was unable to get him into court to testify. Now, of course, Officer Mosley was subsequently available to testify, and I think it's important to note that after the trial had finished, defendant made no motion to set aside the verdict. He made no post-judgment motion. He did not ask for a hearing at which people could produce Officer Mosley to testify as to what, if anything, he had written about the crime. So I think it's arguable as to whether or not defendant has even preserved his claim here. But in any event, Your Honor, just getting to the substance of what we have, it's basically this. We have a complaining witness who testified that he never saw Officer Mosley write anything down. He thought that it was Officer Raycraft who was doing the writing during the time they were on the scene. Officer Raycraft testifies that she wrote nothing. She also said that she saw Officer Mosley writing, but that he was only writing for a period of seconds. She said she did not know what he wrote. She was confused as to where he wrote it. And finally, we have a representation by the prosecutor that 3 different people had searched the files at the Midtown North Precinct, and nobody came up with a complaint report other than the one prepared by Officer Willis, who was the arresting officer, which had already been turned over to defendant. On the basis of all of this, it's clear, Your Honor, that the prosecutor exercised due diligence trying to get this so-called Rosario material, and that he was not able to come up with anything during the trial. Now, even if Officer Raycraft was accurate in her observation that Officer Mosley was writing down something about this case, that alone should not lead to reversal of the judgment. Because first of all, it may have been something as simple as a note in the officer's memo book which referred to the address of the cafe. And if that were true, that would surely be duplicative of everything else that was turned over. However, even if the memo book contained a description of the perpetrator, that description might have been duplicative of what was sent out in the Sprint report, which, by the way, was a very detailed description of the robber, and it is clear, I think, from the record that the report was sent out over the radio, the report of the description of the robber, almost simultaneously with the time that Officer Mosley was talking to the complainant and writing any notes, if in fact he made any.
Ms. Daly, has it been the people's position on the record that as to the existence of this so-called alleged Rosario material, that you're as much in the dark as anybody else?
Well, it was the prosecutor's position at trial that we did not know whether or not Officer Mosley had written anything down. And the prosecutor suggested that if in fact he did make any notes, for example, on a scratch copy of the complaint report, that those notes were either lost or discarded. As the prosecutor pointed out, it was stretching it a bit to think that 4 months after the crime, which is when the trial was occurring, that those scratch notes would still exist. Certainly we know that there was no report in the precinct. That much we can tell. So yes, it is our position that we didn't know at that point. And also that there was no reason to believe that Officer Mosley had written anything down.
Sure. Would that be a sufficient test to guard against mischief or closing one's eyes to the responsibility to come forward with such material? I mean, what check and balance would you introduce to that concern that would be obviously on our minds as well as your adversaries?
I understand that, Your Honor, and I understand that the people have a very high burden of locating and preserving Rosario material. But I think in this case, where there's been virtually no allegation by the defendant that this material was intentionally destroyed, and where there is a good chance that if in fact a complaint report was made that it has since been lost or destroyed, I think that it would be placing too high a burden on the people to call that per se error and to reverse the case. Because after all, even if this material did exist at one point in the form of scratch notes or a complaint report, and even if it were non-duplicative, it's very clear that sending this case back for a new trial wouldn't change the situation, because we wouldn't be able to provide it any more at a second trial than we would have been able to at the first. And certainly, this is not a situation where the judge did not craft a remedy for the alleged Rosario violation. The judge here granted defendant's request for a missing documents charge. And he essentially told the jury that they could find, if they believed that such a report existed, that it was in the people's possession, and that the people had given them no reasonable explanation for turning it over, that they could then hold that against the people and infer that that document would not have supported the people's case.
What about a remedy short of a new trial, for example, a hearing to determine whether in fact this officer himself has the notes or made the notes?
Well, Your Honor, certainly the court could remand the case for a hearing. But my position is that at this point, there's nothing in the record to support a reversal. And even if the court affirmed the judgment, defendant would still be free to bring a motion pursuant to CPL 44010 to call Officer Mosley and to find out whether, in fact, there was any non-duplicative Rosario material that wasn't turned over. Of course, if the court decides not to do that, it can be remanded for a hearing. Officer Mosley clearly is available at this point, and the people would certainly welcome a hearing as opposed to a reversal in this case, because I think that the record simply would not support that particular conclusion. Thank you very much.
Very much.
Called against size.
Good afternoon, Your Honors. I represent Dennis Quirk, President of the New York State Court Officers Association and the Association, in this challenge to the determination of the Classification Review Board regarding the classification and allocation of the court officer position. In reversing special term and upholding the CRB, the appellate division stated that the CRB had found valid distinctions in the job requirements and duties, thus warranting at the allocation of different grade levels. Well, in fact, looking at the record of the CRB's determination on the allocation issue, there is utterly no discussion of job requirements or duties. There is merely a discussion of the salary rate as being comparable to other security titles, such as correction officer or police officer. But there is no examination of job duties. The only examination of job duties and requirements and nature of job and scope of job is in that portion of the CRB determination which deals with classification. Therefore, the conclusion that the appellate division reached, that based on that finding of job requirement and duty comparability, that allocation was appropriate, it follows, therefore, that there was no rational basis for the determination. And in fact, that the allocation issue is not a function separate and apart from the overall review of the nature of the job and its duties. It is for that reason that the appellate division's opinion is error. There is a whole body, as this court knows, of classification determinations under the civil service law. It involves a process which essentially is an analytical of the job at issue. Allocation is a function or a part of that analysis, but one does not allocate a salary to a position or positions before there has been a determination as to the propriety of the classification of the title. The argument of OCA appears to be, on this portion of the case, twofold. Either that the civil service law concepts don't apply, or that there is some distinction between the terms unjust and inequitable as found in the order of the administrative judge, or their second point would seem to be that there is some other applicable standard. Now, the civil service law has long been the basis for all legal review of classification determinations. And that proposition that the civil service law is somehow inapplicable to these positions does not stand, given this court's decisions in many cases, particularly in Evans against Newman, where the court said that personnel actions for non-judicial personnel must be consistent with the civil service law. 39(8)A of the judiciary law is not conceptually different than the civil service law, section 118. They are parallel statutes. They both implicate a requirement of an employer, an agency, here the administrative judge, in establishing titles to premise the determination on essentially a fundamental threshold determination of the nature of the duties, the requirements, and the scope. The Office of Court Administration argues that there can exist two security titles with substantially similar duties, and that is not unjust and inequitable. We argue that the vast body of law disproves that proposition. If they are substantially similar in duties and responsibilities, as the CRB so found, there may not be two titles. Judge Wallach, in looking at the record of the CRB and the arguments made to him by OCA that an employer has a right to have a two-tier system, or that the senior court officer is a supervisory title, rejected all those arguments, not as a fact finder, but as a reviewing court, noting that those arguments had been made to the CRB. The CRB examined and rejected them in its holding, in its finding, in the opinion, that there was substantial similarity in duties, in character and scope of the job, and in the responsibilities involved.
Nonetheless, Ms. Carroll, the difference in classification was upheld by the board, was it not?
Well, it was, and that brings us to the second part of our argument, which Judge Wallach specifically addressed. The CRB was not free to uphold the classification, having made those findings, because those findings have implications, legal implications, based on the civil service law and the judiciary law, requiring that there be a rectification of the disparity, a disparity not founded in the facts presented to the board.
Well, did they actually require that, or did they suggest that in the future it might be an appropriate subject of consideration?
They did suggest consolidation. Our argument is not that that decision was not a possible solution if they had further proceedings. Our position is, as Judge Wallach said, and I think a correct statement of the law, that that was not an option for the CRB, that is, to basically wash its hand of the legal problem it found. It was required to rectify the problem, which brings us, I think, squarely to the issue raised by OCA, which is that the CRB does not have the jurial capacity to write the relations of the parties who appear before it in an appeal. And I think that position is legally wrong, as did Justice Wallach. Judge Wallach said there was no impediment to the CRB's taking corrective legal action. Our argument in that regard is, number one, in the Corkum case, when the question of the nature of the whole review, the administrative review of the classification system was raised, an affidavit was submitted by Richard Bartlett, who was the administrative judge. In that affidavit, he said that the first draft of the appeal procedure indicated that the chief judge, the administrative judge, would be the final arbiter in appeal. In the final version that was adopted, the CRB, posed as or posited as an independent body, was stated to be the final arbiter of the issues raised on an appeal. The language of 2545 NYCRR specifically says the CRB has the authority to hear and determine appeals. And the other point is that the administrative judge order says that the CRB has the authority to reverse and modify. Those terms have long experience in interpretation in many appeal bodies, appellate bodies, administrative appellate bodies, such as the Civil Service Commission in New York City or the State Civil Service Commission, and they have been held to be the authority to determine facts, apply law to those facts, and make determinations on the issues raised before them. And that is what the CRB failed to do. It did half the job, not the full job, and in that sense, we believe Judge Wallach's remand for them to complete the job was appropriate. Our other argument was that this was not an appeal of right because the remand was not for ministerial, but for further adjudications in the appeal. Thank you.
Ms. Satterfield?
Good afternoon, Your Honors. I will focus on the determination of the Classification Review Board to the effect that there is substantial similarities in the duties between the court officer and the senior court officer title. We agree. There is substantial similarities. However, a finding of substantial similarity does not compel one title. It would have been reasonable...
I'm sorry, I didn't hear that. Does not compel what?
It does not compel the utilization of only one title. It certainly would have been reasonable to establish one security title. It is equally reasonable to use two titles. The substantial similarity standard is a standard that is set forth in the civil service law, and for the purposes of this argument, I will refer to the civil service law, even though the judicial branch is governed by, or we have to proceed in accordance with, not governed by. Reference to civil service law states that substantial similarity is the standard that applies to the grouping of positions under common and descriptive titles. The new classifications plan contains well over 8 groupings of positions that are substantially similar. We have the security titles, all of which are substantially similar. We have legal titles, all of which are substantially similar. They are grouped under the title category of legal. We have court reporter titles, more than one, all of which are substantially similar, meaning that the duties that are performed more or less are common to all of the titles.
I guess the concern, really, I'm not speaking only for myself, are the words in the CRB's writing that they're so substantially similar in nature and level as to require a conversion of the title. That is a great concern. Not just substantially similar, it's so substantially similar as to require a conversion of the title.
The Classification Review Board, in finding substantial similarity from the standpoint of the duties and the scope, did not conclude that the titles were so substantially similar that they had to be consolidated. What the board found was that it was reasonable to have the court officer title. It also found that it was reasonable to have the senior court officer title, and it was neither unjust or inequitable to maintain the two titles. It suggested that sometime in the future, the classification authority, the chief administrative judge, may review those duties for the purpose of possible consolidation. Possible consolidation. The board did not come to the conclusion that based on the facts before it, that we were dealing with titles with identical functions. It rejected the claim that the supervisory positions or responsibilities justified the distinctions. It rejected that. But it did embrace the concept that it is perfectly appropriate to have two titles. One an entry-level title and the other a promotional level title.
In making the determination of whether there should be a consolidation of the titles, of course, a comparison of the job descriptions is one of the criteria, I assume. And if this should be reconsidered at a future time, as this seems to suggest it should, would it be relevant in such a consideration to consider the difference in volume of work? I noticed that in the decision it says that Nassau County has 30 times more criminal dispositions than other places, and also the criticality and complexity of the work. Are those valid considerations in determining whether there should be a consolidation if the job descriptions are the same?
The first volume of work would not be a valid consideration. That is a function of staffing. With respect to criticality, and that gets into the second phase of the argument, what compels a consolidation of substantially similar duty of titles is the finding that the degree of substantiality between two different positions are so equivalent that one title is required. There is a difference in degree between the functions of your senior court officer and your court officer that is reflected by the different type of procedure that a senior court officer must be involved with. I will give an example. we make reference frequently to the distinctions between the felony trial and the misdemeanor trial. There may, on the surface, seem to be very little difference between the actual articulated duties that must be performed, security duties. But when you're speaking in terms of the responsibilities or functions related to the jury, a jury that is going to sit perhaps for a substantial period of time or even maybe a short span of time. But let's focus on the lengthy period of time, where the jury, in fact, may even be sequestered. The role of the senior court officers in that particular circumstance involves not only the protecting of the jurors or the providing of data to the jurors in the jury deliberation room, but you're also getting into the requirement of transporting the jurors from the court facility to the hotel. Under certain circumstances, transporting the juror from the court environment to his or her own personal location. In many instances, I am advised, the action of the Supreme Court officer very conceivably could result in a mistrial. So that after much time has been expended,
Well, that could be for any court officer in any trial, couldn't it?
the distinction, Your Honor, however,
Could be in the county
is,
court, not only the Supreme Court.
the distinction, however, would have to be made, Your Honor, it would be this. Your misdemeanor trial, as a general rule, and I must speak it generally, does not last for the length of time frequently that your felony trial lasts. So that the margin of error.
Excuse me, but any trial affects a defendant who is on trial, and that's what we're interested in.
I'm sorry, Your Honor, I did not hear you.
Any trial affects a defendant, and that is what we're interested in, not the length.
Of course, Your Honor, but we are speaking in terms of the length has a impact upon the function of the SCO, and that's what we're looking at. We are seeking to compare the distinctions, as they are, between the senior court officer and the court officer. And we are saying, and if I may point this out, please, it must be remembered that for just about the whole year of the court officer's employment, it's spent in training. The court officer, as well as the senior court officer, is a peace officer. Critical to the performance of that public employment as a peace officer is becoming trained in the use of firearms, becoming acclimated to the powers of that peace officer. This is not a training process that takes place for the senior court officer.
But you have
He acquires
may I
this
ask you
as a
question?
court officer.
Don't senior court officers also sit on, aren't they in courtrooms with regard to civil cases?
Yes, they are, Your Honor.
Okay, you're talking mainly because of the peace officer status and the criminal case. How about the civil case?
The court officer, as well as the senior court officer, no matter what the assignment, the court of assignment, continues to be a peace officer having all of the powers set forth in the statute of a peace officer.
You talked about the length of trial. You tried to tell me about the length of trial. Now, what about a senior court officer who is assigned to Part 1 where all the cases are being either settled or sent to parts?
Your Honor, there are, I repeat, many different circumstances or assignments for the Supreme Court officer, as senior court officer, as well as the court officer. The test that is administered for each of those titles applies to any of the assignments.
How about the court officer in the criminal court who is there for arraignments of felonies, where the burden and the amount of arraignments each day are in the hundreds and sometimes many hundreds?
Your Honor, you are again addressing volume when you say in the hundreds. The chief administrative judge made a determination that is reasonable, that experience in the civil, criminal, family court environment would be a necessary experience factor for the promotion or elevation of that court officer to the higher title of promotion of senior court officer. Is that unreasonable? No, it is not, Your Honor. There is a difference. Thank you.
Thank you, Your Honor. I represent the New York State Supreme Court Officers Association, which is an intervener in these proceedings. And it is a collective bargaining representative of the senior court officers who provide security services in the Supreme Court parts in the city of New York. I think one of the critical issues in this case, and one that has been somewhat obscured throughout the proceeding, is the appropriate scope of review of this court and the precise determination that it is reviewing. I think that the presence of the review board has somewhat obscured the fact that the underlying determination that is at issue here is the allocation and classification of court officers by the Office of Court Administration to the title of court officer and to line 18. The review of that determination by the courts is in the nature of a proceeding in mandamus that has been established, I think, without serious dispute since at least the Grossman versus Rankin decision in 1977, and was further elaborated upon by this court in Dillon versus Nassau County Civil Service Commission, decided in 1978. In those decisions, the court observed that the standard of review that is used in reviewing determinations by civil service commissions has not been casually formulated. And that standard is that the decision of the commissions must be affirmed unless they are arbitrary, capricious, or affected by an error of law. The court refined that standard in Dillon by noting that the petitioner, in seeking to overturn the classification decision, must show that the determination by which he feels aggrieved cannot stand on any reasonable basis. The determination, I submit, that the court was talking about there, and which we should be talking about here, is the determination, the original determination of the chief administrative judge allocating court officers to the title of court officer and to line 18. Now, the presence of the Classification Review Board, I suggest, has obscured that fact, and in the process has perhaps confused the appropriate standard of review and the appropriate burden of the petitioner in this case. The Classification Review Board is not a statutory agency. It was established pursuant to an administrative order of the chief administrative judge. It need not have been established at all. And once established, it could have been given much more restrictive powers than it was given. But the chief administrative judge, in his discretion, determined that an internal appellate system might result in the elimination of what otherwise could be time-consuming appeals to the judiciary. Now, when you read on page 468 of the record, the order establishing that body, you will note that it is simply authorized to reverse or modify the appellate decision of the chief administrative judge, who is the first line of appeal in grievances arising out of the classification system created by the Office of Court Administration. Now, I think this point is important because Certainly, Judge Wallach was, I think, misled and confused by the presence of the Classification Review Board and perhaps even the Appellate Division. The classification, Judge Wallach seemed to regard the Classification Review Board as a quasi-judicial body, which was authorized and perhaps even mandated to compile a record upon which it made findings of fact, and that it was then confined to these findings of fact in drawing its conclusions of law. In reality, the Classification Review Board is not required to hold any hearings at all. In its own internal procedural rules, it states that it may, at its discretion, hold a hearing on any aspect of the appeal. It is certainly not required to hold a hearing. And then I think if you...
What is its function exactly?
Its function, I think...
It's a hearing or not, it makes recommendations.
Well, its function, I think, is described precisely in the order that created it, and that is the only source that we can look to. Its function is to reverse or modify decisions, appellate decisions of the chief administrative judge that it finds are unjust or inequitable. That's its function. And it can do so without holding a single hearing or without making a single finding of fact or without issuing anything more than a one-line decision. It had no requirement that it issue the elaborate decision that it did, nor that it make any findings of fact. And I think, Your Honors, if you look at the record, which was compiled by the Classification Review Board, you get some sense of the inappropriateness of the description, finding of fact, used by Judge Wallach.
One other question. I'm a little confused now as to what administrative determination is involved.
I think, Your Honor, there can only be one administrative...
Is it the chief administrative judge's determination, or is it the determination of the CRB that's involved in this proceeding?
I think it can only be the decision of the chief administrative judge.
Could the CRB have changed the classification here if it chose to?
No, Your Honor, I think the state has argued that point in its brief, and I completely support its position that the only power that the Classification Review Board would have would be to reverse or modify an appellate decision of the chief administrative judge, not to make an allocation or classification decision itself. It's clear that the chief administrative judge, even if he could have, and I doubt he could have, did not delegate his constitutional authority to this body. Therefore, the determination that is appropriately reviewed by this court is the determination of the chief administrative judge allocating court officers to that title and to line 18.
Well, the